Welcome to Hull and Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you are listening to will provide information and insights into estate planning in Canada. From the offices of Hull and Toronto, here are Ian and Suzana.
Hi, and welcome to Hull and Estate and Succession Planning. You're listening to episode 174 of our podcast on Tuesday, July 28th, 2009.
Hi, Suzana.
Hi there, Ian.
How are you?
Fine, thank you. And you?
I'm fine.
That's great.
Do you want to talk a bit? Do you want to
talk about feelings?
Exactly.
Is that what you're getting at?
Exactly.
No, it's okay.
I'm taking a lot of criticism from the blogosphere about my inability to communicate with you. So, all I can do is present. I can't communicate. Okay, so let's keep working through this because on the sunny days of summer we have an agreement that we've been walking through. We talked a little bit about this idea that we'll take let's document the plan of action. How are we going to transfer it down to the next generation, not just throw it at them and say, you figure it out. Mm-hmm. Let's help them, walk them through it, hold their hand a little bit. And part of the way we do it is either we set up a trust or we set up a co-ownership or a co-tenancy agreement or something like that. It's trust law or contract law. Mm-hmm. And we talked about that in our last podcast. Now, on this podcast, we ended up in our last podcast talking about the importance of creating a decision-making process. And again, it's easier to do, as you said in our last podcast, in a kind of a contract environment. But once we've created the decision-making process and we talked about some of the options, majority rules, semi-majority, 75% vote has to have a decision. If you're going to put a new roof on the cottage, 2/3 of the ownership has to agree. I don't know, the capital expenses. You can categorize a lot of these, and good drafters can pick up on issues that you can identify.
Right.
So the decision-making process, while there's lots of choices, it's something that shouldn't be overlooked because we've got a pool of money that we've created, hopefully, or a funding mechanism. Now we've got a decision-making process, and then the next thing we want to talk about is, and what is sort of a classic problem, is scheduling of the use of the property.
And that really is one of the flashpoints, I'd say, particularly in the best weather and the best season when the cottage is most demanded by the family members or the individuals who are going to be sharing it. And so some mechanism really does have to be put into place and documented because it's easy to try to avoid the flexibility of the arrangement, but not necessarily something that's easy to deal with emotionally.
Absolutely, and where you learn a little bit of the sophistication of these agreements is when you look at, in Ontario, a big trend in the past 10 years has been partial ownership or sort of almost timeshare ownership of cottage properties, and those corporations have developed pretty sophisticated schemes as to who gets what weeks and so on. But some of them that I was looking into before this podcast, one of them gives the purchaser guaranteed 5 weeks use of the cottage for a year, 2 weeks in the summer, and then they get into this scheduling program that it's first come, first served. Right. I mean, we can get that elaborate. That's sort of one end of the scale. And the other end of the scale is we set out in our brochure, it's like, you know what, maybe every year at the beginning of the year you draw straws. I mean, that's an unsophisticated way of dealing with it. And then you pick weeks. You have to be sensitive to the fact that some people always get their holidays during the second week of July or something, and maybe that's got to be accommodated. But like you say, it should be anyway. We always recommend it be documented in some way, even if it's a process as opposed to anything else. With good communication, you can help avoid some tension and choices and
that's
so on.
For sure.
So that's just another sort of cornerstone. And what we're trying to do in this series is just hit the hot button items, throw some examples of what we've seen that work in these agreements, and make sure that it gives people something to think about. All right. So those are all the happy things, and we're going to all agree on what dates we're going to go up and so forth. But what about the negatives? And that is, what about the consequences of default?
And when you say default, Ian, I'm presuming you mean if there's an agreement that's been put in place, whether it's a trust arrangement or a contractual one, you've agreed to certain things and now you're not upholding your end of the bargain. Is that what you're getting at?
Well, exactly. If you've come up with a scheme of a plan of action and one of the parties isn't paying their funding portion, or someone isn't prepared to accommodate the choice of weeks process that you've
You're not getting into trespass law or anything like that, are you? Because it's way out of our league.
no, that would not be my strength for sure. But and again, it comes back to what you said before. In a trust environment, it's more difficult to deal with this issue. But in a contract, co-ownership, co-tenancy agreement, and we're not sort of pushing that because the trust brings with it its own protections and the co-tenancy agreement brings its own protections. But you can see the flexibility is more limited with a trust environment, because if a beneficiary defaults, you don't have the same sort of ability to basically kick them out.
That's right.
As easily, anyway.
Or to seek some kind of remedy from a judge. It's a little bit more, certainly, I would say judges would be a bit more reluctant to interfere with a trust-like arrangement, unless it's the trustee who's necessarily, acting improperly, than in a contractual arrangement amongst family members where, they're sort of governed by, this is what you have to do.
Absolutely. So I think the real message with this is that the agreement should include strong default clauses and steps that everybody can agree to before default occurs.
Right.
Because what happens in a lot of these, again, I mean, if you look at the hot button issues of why these transfers to the next generation don't work, one of them is that people build up and stew about the fact that Betty didn't put in her $2,000 this year, and everyone else had to put in an extra. Well, Betty's going through a tough time, but there was no consequence. There was no, I mean, even if you, for example, if someone couldn't fund it because they ran into an employment situation where they didn't have any money to pay for it or something, you can always say, well, look, you don't lose your interest in the property, but you will lose, it's diminished by that amount.
Right.
And so if you accumulate 5 or 6 years, maybe after a certain point in time you say that's far enough because the others can't afford to carry it, but you have lots of flexibility to say, you know what, all it's going to do is diminish what I'm ultimately going to get out of the property or something like that. If you can anticipate those kind of scenarios where people know there's a cause and effect.
Right.
If they know the default consequences before they go into it, it helps, again, diffuse the situation.
For sure. And we've seen in some interesting situations where people will build in, either a family meeting kind of provision, a mini arbitration, mini mediation kind of provision. If the people just can't agree, they agree in advance that it will be, ultimately resolved by someone other than a judge, so that you don't get into that kind of a contentious environment.
And that's absolutely right. I mean, you can phase it in. You can sort of say, all right, majority could rule and make the decision without bringing any third parties in, and if that doesn't work, then you go to a mediation or arbitration. If that doesn't work, then people can have their rights. I mean, some of this seems a little elaborate and maybe bureaucratic, but that we come back to one of the themes that we can't forget about family cottages, and that is they are emotional property. They are not typically seen as just a cottage by most of the next generation, and so people will go pretty far to maintain their interest if they really want to hang on to it.
And like you said earlier, they might as well know what the consequences of not following through on what they've agreed to would ultimately be.
Absolutely. All right, so we've got that sort of unhappy consequence of default aspect of any agreement. Let's get unhappier, and that is what happens if one of the co-owners or a beneficiary dies. Once the transition is made, the property's in the hands of the next generation, and then unfortunately that generation, someone dies.
And I think there's going to be two different sets of consequences, and much more clearly delineated if you've got a trust arrangement or if you've got a contractual one.
Absolutely. Again, you're running into some of the complexities and so forth that get created in a trust arrangement and so forth. All right, well, on that happy note, let's wind up for today's podcast and really look forward to some of these scenarios, but we've got all of these different variables that we're sort of trying to compact in, and hopefully we're going to come up with this wonderful agreement that's going to eliminate all fights for the future and forever.
That's right.
No pressure.
And we're out of business.
That's right. All right, well, thank you very much.
Thanks, Ian.
You have been listening to Hall and Estate and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast you've been listening to is provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.